not hearing any corrections, we'll move on to department reports. The first report is the enforcement report. Bill.
Thank you. So we only met like 2 months ago, am I correct? So it's been a kind of a short gap in between. So obviously the statistics I'm going to give you reflect that. Actually, I think we met literally 2 months to the day ago in February, right? Or 17th, give or take a day. In that 2 month or 8 week period of time, we received 95 real estate complaints from consumers and or cases that were initiated by the state's own action. And during that same period of time, 71 investigations were completed. Dispositions came out of enforcement. When I say completed, it could go in a couple of different directions. So of those 71, 14 were referred to our legal folks for hearing consideration. 57, the balance of that, were closed within enforcement. I do have some numbers for the breakdown. Of those 57, 21 were closed, no jurisdiction, no merit, no violation, insufficient evidence. They kind of all fall under the same heading of, the decision was made, it was not worthy of any further action for one or more of those reasons. Another 21, coincidentally enough, where the disposition on the file was instruct, warning, settled, or otherwise resolved. Through supervision, our enforcement folks decide whether or not, even though there may be a violation, it doesn't rise to the level of referral to our legal folks, and we issue letters of warning, instruction, compliance statements are obtained, etc. 2 of the 57 were deemed to be civil in nature. 3 were closed with a hold, and I've said this before, but some folks may not have been there. When we close a file with a hold, it generally means the license, it's a minor issue. The licensee could not be contacted. They their license has already expired or they're about to expire. And rather, because we can't communicate with the licensee for any number of reasons, we simply put a hold on their record, which gives us an opportunity to address that issue, which has not been resolved when and if they attempt to renew their license. 5 were deemed abandoned or withdrawn. 1 was a duplicate, and 4 were otherwise closed. We have a whole variety of different disposition labels. So otherwise, could mean any number of different things, but the other disposition labels did not apply. I know the Director of Licensing, Jody DeLello, is going to talk a little bit about the standard operating procedure, new regulation. Is it regulation or statute? It goes into effect next week, I think. But anyway, I just wanted to mention that the enforcement staff has been briefed on it. There's still a couple little wrinkles to iron out just in terms of our full understanding of what's expected of the industry, and then in turn our ability to enforce it. So our enforcement staff have been briefed on it and are prepared to implement it into our normal enforcement procedures. So, but as I said, I think Jody's going to talk, or maybe Dave is going to talk a little bit about that as well. That's the end of my report.
Thank you, John. Do any of the board members have questions for John?
Question. I'm sorry.
You're at the unmute.
Oh, you've done me.
Yes, I know.
Okay. Morning. When they are not, no follow-up, has the consumer been referred to another agency, respected agency that could probably help them, whether it's the district attorney's office or just another agency, since you stated that DOS cannot do anything because the person is not licensed? And my second question is, with the new surcharge for the license, understanding that that new surcharge is for testing. Is testing being implemented so we can have less enforcement issues?
Well, as far as the first question goes, yes, that's we get lots of complaints where someone may be filing a complaint against a dentist, a physician, someone who is licensed by another agency. It may involve localities, contractors, and so forth. So yes, no, we make an effort to, if we have that information available, to inform the consumer what regulatory body they can go to, since it's not within our jurisdiction. So That's the answer to your first question. Very often they're complaining about things that are not a regulated issue, and the answer would be the same. If we're not aware of who can help them, and that probably would fall in the category where we feel something is civil in nature, where it's a civil dispute, that their best recourse is to consult an attorney and/or perhaps pursue it in the civil realm. As far as the testing goes, I am familiar with what you're talking about. We have not been at the enforcement level briefed much beyond the surcharge, and that money, I was under the impression that money was to be diverted. I don't know what that sounds like, a negative word, but diverted to the Attorney General's office for them to administer a testing process. Perhaps Dave can talk about that.
Okay.
But it's really in its infancy, and I don't really know more about it other than that.
Thank you.
And I think the whole thing is designed to detect, discriminatory practice within the industry, and yes, hopefully, like any enforcement program, prevent further occurrence. So yeah.
So I can provide a little bit more background on that. So part of the fair housing bills that I had discussed at the last board meeting, I believe I had mentioned that 50% of fines imposed pursuant to RPL 441C, as well as an additional surcharge on new and renewals licenses, are, as John said, being diverted to a special fund that was enacted under those laws pursuant to State Finance Law Section 80-A. So once those funds are deposited by the department into that account, as John had mentioned, other agencies are responsible for actually getting access to those funds and to administer it for testing. The department, we don't have access directly to use any of those funds. We just transfer it over pursuant to the State Finance Law.
Thank you.
Mm-hmm.
Thank you. I see you've been joined by folks in Rochester. I'm sorry that the image is very small. Who's in attendance in Rochester, please?
David Dworkin, hi Duncan, and others. Hello everyone. Sorry, I was out in the cold, the door was locked.
Yeah, no problem. I only heard you say
There's Dave and Eddie Clark,
Eddie
both
Clark,
in Rochester. Okay. So we have 6 present physically, and then David Mossberg. I don't know if he counts. If he does, and he makes 7, then we would have a quorum.
Well, we have 7. We have Zendaya, Tricia,
you
Diane.
can't count attendance for anyone who's
No.
virtual.
Wait, so I was going to jump into this in sort of the new business to give a very brief update on recent legislation regarding the open meeting laws. Just to avoid any sort of confusion, Zendaya, who's appearing virtually, she can count towards appearance today and quorum today, so that's not a problem. In terms of board representative on behalf of the Secretary of State, that would actually be Director Jody DeLallo. I believe she's the appointed designee, so it wouldn't be me. So for the purposes of quorum, it could be all of those present, at a DOS office currently, plus Director DeLallo, as well as the other member, Espedita, appearing virtually.
Great, Dave, thank you. Since we do not have a quorum, we'll move back to...
We do now, don't we?
We do. We have a quorum now.
Okay, can we approve the meeting?
Yeah, we're going to go back. Yeah.
Okay.
So we're going to go back to item 1, which would be approval of the February 17th meetings. Could I have a motion, please?
1, 2, 3.
I'm happy to.
4,
All right, a second, please.
5, 6, 7, 8.
All right, all those in favor? Any in opposition?
Aye.
Okay, thank you. The minutes are approved as presented. Moving back to agenda item 2B, the processing report from Emily, is it Loopy or Loopy? Loopy, thank you.
Good afternoon. Included in the material you were provided is a report of the number of current real estate licensees for March of 2021 and February of 2022. The report groups licensees into broker and branch office licenses and salesperson licenses. The totals are listed by county. Please note that the 2021 numbers include only licensees and do not include those licensees whose licenses may have expired but were covered by Executive Order 206.11, which had allowed individuals licensed by the Department of State to extend the expiration of their license during the state of emergency. And that concludes the processing report.
Does anyone have any questions for Emily? Not seeing any, thank you, Emily. The education report, Allison Lacey.
Good afternoon. Legislation revising the real estate property law regarding the continuing education requirements for real estate salespersons and brokers was recently adopted. The law adds 2 hours on cultural competency and 2 hours on the subject of implicit bias to the required topics for renewal. Effective September 21st, 2022, as part of the 22.5 hours of continuing education, not in addition to, as part of the hours. Both real estate salespersons and brokers will be required to complete at least 2 hours of instruction pertaining to implicit bias awareness and at least 2 hours of cultural competency training. Implicit bias is defined as the attitudes or stereotypes that affect an individual's understanding, actions, and decisions in an unconscious manner. Cultural competency is defined as understanding cultural norms, preferences, and challenges within our diverse communities. The requirements are based on license expiration date rather than the date the renewal application is submitted for processing. Schools have already begun submitting applications for approval of these new topics. Are there any questions?
All right, not seeing any, thank you very much, Allison. Okay, the examination report, Shannon McGuire.
Thank you. During the first quarter of 2022, the real estate salesperson examination was 6,316 individuals with a pass rate of 52%. In that same time frame, the real estate broker exam was administered to 569 individuals with a pass rate of 53%. In March 2022, we began increasing capacities at our exam sites with the goal of being back to 100% capacity by July 2022. The average current wait time for an exam statewide is approximately 50 days. In February of 2022, the average wait time was 6 weeks. The current wait time in those regions is now 3 weeks, and we expect that to continue to improve as we increase capacity. Thank you.
Great, does anybody have any questions for Shannon? Thank you very much. Okay, we'll move to new business. Jody, the communications to real estate licensees.
Hi, good afternoon. As John Goldman mentioned in his enforcement report, effective April 20th, which is tomorrow, real estate brokers are required to institute standardized operating procedures. I just wanted to let the board know that emails were sent to real estate licensees, informing them of this new requirement, and the email provided highlights of the new law. An email blast was sent to real estate licensees on March 18th, and then a reminder was sent on April 5th, again on April 12th, and then just this morning, April 19th, the last of the weekly emails have been sent just to inform real estate licensees of this new requirement. So if people, are getting inundated with emails, that was on purpose. And then Allison mentioned the new continuing education requirements that will be coming effective in September, on September 21st. So an email blast was sent on March 22nd, letting real estate licensees know about that new requirement. And as Allison stated, some of our real estate schools have already received approval for continuing education courses to meet the new criteria. As we get closer, as you know, at the end of this meeting, there's a public hearing about the curriculum that will become effective in December. Once we get closer to that date and have more concrete information about the impact, what the requirements will be, we'll send that information out to real estate licensees as well. And this information obviously will be posted on our website. That's it. Any questions?
Jody, and I believe you're on for item B, which is the education subcommittee, or did you combine those two there? They're both combined?
Okay, yeah, so good. So, right, so, also, this public hearing that is going to take place at the conclusion of the board meeting. Once we hear comments from those in attendance that choose to speak, the department will take that information. And also, we sent an email out to the real estate board members to see who would be interested in volunteering to serve on a subcommittee of the board to specifically discuss the new curriculum. So I know we have 3 individuals so far that have volunteered. I'm going to ask Denise to reach out, maybe even within the next week, to schedule a meeting for the subcommittee to have their first discussion on this topic. If anyone else on the board is interested in serving on that subcommittee, just send an email to Denise.
Thank you. Are there any questions for Jody on either item? Thank you, Jody. The next item, our next meeting is scheduled for July 21st at 1 p.m.
Duncan?
Yes, I'm sorry.
Sorry, I thought if it's all right with the board, I would provide a little update on the governor's executive order that was signed on Friday that relates in part to the open meeting laws, which may help the board in scheduling the next meeting. That's all right?
Yes, of course. Yeah, please.
So, as we all know, since the start of the pandemic, we had been operating under various executive orders, which has allowed not only this board but other bodies subject to the open meeting laws to meet virtually. Those orders had been continued then early in 2020, actually Chapter 1 of the laws of 2022. There was a change in the open meeting laws to effectively allow virtual meetings for as long as there is an executive order that's signed by the governor. The executive order that was scheduled to expire right before this meeting happened to have been extended pursuant to Executive Order 11.5, which occurred last week, Friday. So before Friday, there was sort of a question as to whether or not that would have been extended, which is why some board members are appearing virtually and still count for a quorum, and why others are here. Related to that, and so that executive order is only going to be valid for another 30 days, and so we'll have to sort of see what happens and if that gets extended again by the governor. Related to that is on April 9th, the governor approved Chapter 56 of the laws of 2022, which is sort of a permanent law to address the quote-unquote extraordinary circumstances. So at some point, we all hope that these executive orders are apologize for that. So as I was saying, at some point, all these executive orders are going to end, and what will take its place is the new law, as I had mentioned, signed Chapter 56 of the laws of 2022, which will allow public bodies to have some virtual component going forward. the thing that I wanted to mention to the board about that in particular is that it is not for every board meeting. And the law is so new that we're still sort of waiting for guidance and opinions from the Committee on Open Government on how that law is going to be applied. But the very broad or high level sort of view is that the boards are going to be allowed to create written policies and procedures that will allow specific board members to basically appear virtually under established extraordinary circumstances. And so the current statute, for example, lists like illness and some other extraordinary circumstances that would exempt that particular individual board member from having to appear in person. But the rest of the board would still have to appear at a public location, and the majority of the quorum would have to be available at that public location. And so prior to anyone being able to take advantage of or to claim an extraordinary circumstance, the public body has to meet at a public meeting. There has to be a formal vote and resolution on, for example, saying, this public body will, institute a procedure or policy to define extraordinary circumstances, and here's the public policy, and here's those written procedures, and that also has to then be posted on the public body's website. And so that law is going to go into effect on June 8th. Or that's when these requirements are going to take place. So, it's unclear, and I don't think anyone at the department is in a position to predict whether or not these executive orders are going to continue past June 8th. If they do not, after June 8th, it would appear under this new law, all public members or all of the members would have to appear at a public location. You could not appear virtually unless it was an extraordinary circumstance, which has to be defined and voted on by the board, at a different public hearing. So for scheduling purposes, I'll leave it up to the board, but if the next scheduled board meeting is July 21st, that's obviously after, June 8th. And so if the board were to adopt a resolution defining extraordinary circumstances, if it was on July 21st and there was no executive order, it would have to be in person at one of, our regular locations, Rochester, Albany, or New York. So I just wanted to explain that to the board. If there are any questions, I'll do my best to answer them now or certainly at our next board meeting. But as I said, we are waiting for additional information from the Committee on Open Government on how to apply the new statute. So I don't know if anyone has any questions.
I have a question pertaining to something else, but I just want to make sure.
Okay. Does anyone have a question about what I just mentioned on the OML?
I know, I guess we're just in a wait and see. We get the meeting dates from the department, so we don't really vet them among the members too frequently. So I would say we would be flexible as a board for the most part, whatever makes the most sense in creating the most flexible participation. So I guess we would leave it to the department, for you, David, to let us know when we can take some action to create the greatest participation. And I suppose that would be to create a system that would allow people to appear virtually under those extraordinary circumstances.
Right. So, the board would have to appear at this point, at some point before June 8th, virtually, if they were going to propose a resolution and establish a written procedure so that for future board meetings, if there's no executive order, if one board member, for example, is ill or, subject to an extraordinary circumstance, that one board member would be able to appear virtually, whereas everyone else would then have to go to the public location.
So I guess I would say, unless there's an objection from anyone from the board, why doesn't the DOS come up with a few dates for us to meet before June 8th so we can take care of this bit of business? Does anyone on the board have any concern about that or any comment? All right, so we'll address that housekeeping at some point before June 8th at a date to be proposed by the department. So for the moment, I'm going to turn over the chair to the secretary, Neil Garfinkel, just so I can bring up an item under new business.
Okay, Duncan.
Thank you, Neil. As some of you may know, a new standard for measuring for appraisal purposes, the ANSI standard, is now in effect for Fannie Mae mortgages. There is some concern that I'm hearing in the field that homes that once were measured at 100 square feet under the previous measuring paradigm could now be at a much less amount, or perhaps a larger amount, I suppose, but generally a much lesser amount under these new ANSI requirements. It is slowly trickling into the practical part of our business. And I guess I would just like to bring to the department's attention that there are concerns about this. I'm not sure what kind of resolution we would have, as this is something that's done by Fannie Mae, and I'm not sure what, if any response the state can do if there's a need to find some mitigation. But I just wanted to bring it to the board's attention that I am hearing it from my members, and I believe it will impact your businesses or many of your businesses along the way. So with that, I'll conclude. And Neil, if it's all right, I'll take the chair back. And is there any other new business to come before the board?
I had a few questions, but I don't know if it's new business. It's just a few questions.
Sure, no, go ahead.
Thank you. So the standards and procedures, is there any type of enforcement that the Department of State is going to be doing to make sure that all the brokers have it on their website going forward? Or is it only going to be if there's a problem, then it's checked?
I think that's probably a question for John.
Yeah, well, it's going to kind of become part of our investigative process. I'll just use the example of, for example, agency disclosure. Whenever we are investigating a transaction, auditing a transaction that's part of a complaint, a transactional complaint, there's a laundry list of things that we look for. As you would imagine, amongst those are the practitioners licensed, are they associated? If agency forms are required, are they in place and correctly completed? And so some of these new things that have, come within the regulatory scheme of how practitioners have to operate are just being added on to the list, such as fair housing disclosure.
Okay.
A few years ago, we revamped. Dave worked very hard on revamping the advertising regulations, which very clearly specify things such as the use of proper license titles and how aliases or nicknames are to be represented in marketing. So we looked at that, and so this is just an add-on to those types of things. We're going to be, anytime we are investigating a complaint, we're going to be looking at, is the SOP available? Is it posted on websites and so forth and so on? Ironically enough, I did have a conversation this morning that is not that's been discussed about perhaps having a targeted enforcement action where we have folks that are dedicated to look at websites and to ensure that these things are in place. That's something that's being discussed, meaning that those folks, that's the enforcement folks, that is their assignment, is to look at websites through, at randomly through sources and to see whether or not these things are being complied with. And if not, of course, we would potentially institute some sort of disciplinary action or at least compliance action to ensure that it's remedied.
Thank you. I have another question. So the new login is supposed to, if I'm correct, replace the e-access? Is that what's happening?
I'm not sure.
The Department of State put out that there's going to be a new New York City government ID. I got this email and I looked further into it. So I just want to know if e-access was going to be upgraded. Is that part of it? I guess not, because no one knows about it. All right. So I had the email. I got an email. Not at the moment. Okay. And my last question is regarding the office manager. So when an associate broker becomes an associate broker and they want to be an office manager, they have to be an office manager for 2 years. Am I correct? So how is that different from someone deciding not to be an associate broker and becoming a broker without having those same 2 years? I'm just trying to understand the new guidelines.
I think Dave is probably best.
Yeah, Dave, can you answer that by any chance?
Yeah, guess, I'm not understanding that question.
So the new law states that anyone who becomes an office manager has to act as an office manager for 2 years, which is a little confusing because this is. However, if you become a broker, I guess you bypass that if you don't want to become an office manager, you go straight to be a broker. I'm just trying to understand.
So, well, the associate broker has already qualified and has met the requirements to be a broker of record.
Correct.
So it would be any sort of misconduct potentially rests on the broker.
Right.
So what the law seems to want to do is to say that if you're going to be an office manager who wouldn't necessarily or ordinarily be expected to have the same level of supervision of everyone else in that office.
You have to be an associate broker to be an office manager.
Correct.
Correct. Okay.
But what it wants to do is it requires them, before they assume the responsibility of being the office manager for that branch, to have training. Whereas if they just became a broker of record, they would automatically potentially be sort
responsible
of, because they're the broker of record.
So that's a requirement of Department of State and
Well,
not
it's just-
the broker of record.
Well, this is statutory change. So
Okay.
the law was changed to say that if you're going to be a new office manager, you have to have at least 2 years of 2 of the 4 prior years of appointment as an office manager of experience.
But then you don't need that requirement if you just want to go straight and be a broker. If you want to bypass
If you want to
that-
be your own, right, because at that point it's assumed that you're going to be responsible for everything anyway because you're the broker of record.
But you just don't need that training.
You would have to satisfy the regular requirements like the exam, the education.
Well, everyone does. Associate
Right.
broker does.
Yes, yeah.
Okay. It doesn't really make sense, but it's okay.
It-
Because one, you could just say, I want to bypass the 2 years and just become a broker.
But then you're responsible for the entire sort of operation and duties because you're the broker of record.
But you still miss that 2 years of training. But I get it.
You miss the 2 years experience as a supervisor, effectively as an office manager, but you have that other experience. The law wasn't, I don't think, designed to stop people from being able to become new brokers if they were qualified, because they're assuming the responsibility of everything that goes on. But if you're assuming the responsibility as an office manager, who then reports up to the broker, they wanted those individuals to have more experience.
Right, but if I take the option of becoming a broker,
Then
I'm not getting that same
Correct.
training that I think
you're
essentially that's what they're trying to do is say you need more training. So if I know I have to go for that training, I may skip that and go for a broker and still could cause the same liability because I don't have the training as the office manager. I see what you're saying, but it just doesn't make any sense. I get it.
yeah.
Okay, thank you, I understand.
All right, thank you. Is there any other business to come before the board?
Nope.
All right, not seeing any. Thank you, everyone, for coming. Our meeting is adjourned. And Dave, I'll turn it over to you.
All right, thank you. So, apologize to everyone here. So the purpose of the public hearing section, which is apart from the regularly scheduled board meeting that was just adjourned, is required by New York Real Property Law, Section 442I, Paragraph 6, which requires that the board meet no fewer than 3 times per year at various locations, one in New York City, Buffalo, Albany. The purpose of the hearings is to solicit from members of the public suggestions, comments, and observations about real estate practice in New York. Additional notice was provided by the department in relation to the public hearing that we would be soliciting from members of the public comments, feedback, and input with respect to a provision that was recently enacted under Chapter 697 of the laws of 2021, also known as Senate Bill 2132B. That legislation states in relevant part that the Secretary of State shall, upon notice in a public hearing, this is the public hearing for that, promulgate rules establishing the content of instruction pertaining to fair housing and or discrimination in the sale or rental of real property or an interest in real property as required by paragraph A of this subdivision being 3 of section 441. The statute goes on to state, quote, such instruction shall include but not be limited to courses on 1, the legacy of segregation, unequal treatment, and historic lack of access to opportunity in housing. 2, unequal access to amenities and resources on the basis of race, disability, and other protected characteristics. 3, federal, state, and local fair housing laws. And 4, anti-bias training. The notice that went out requested that those members of the public that wish to speak pre-register. I know that from looking at the WebEx, there are members of the public here. So I'm going to ask that if there's any members of the public that haven't pre-registered or aren't sure if they did, to please raise your hand using the WebEx feature, and we'll call on you to speak to provide information. Before we go to the public members, I'm going to ask if there are any members of the board that would like to speak or provide comment on the educational requirements that I had just described. Are any members in the board from Albany that would like to say anything?
There's nobody here, Dave.
Okay. Rochester?
No one here.
Nope.
New York? I know that there are some people that have pre-registered from, but I'm asking.
Just for my, I just wanted to, I volunteered to be on the subcommittee, and I look forward to working with everyone to create input and create a curriculum that is appropriate towards these measures.
Oh, okay. Thank you. So if there are no members of the state statutory board, I do have a list of 2 individuals that had pre-registered. So if we could please unmute Sarah Henkind if you're there.
I'm here. Can you hear me?
We can hear you.
Okay. Hello, everyone. My name is Sarah Henkind. I'm the Director of Industry Education at REBNY. Just echoing what Neil had to say, I want to say that we are in favor of enhancing our fair housing training, and we are happy with the DOS as they provide guidance on the content of the 2 mandatory classes that are new. We would also welcome the opportunity to work with the State Board and NYSAR to develop a curriculum that meets the objectives for the cultural competency and implicit bias courses. So we are here to support fair housing laws, and we want to be part of the solution. And please let us know how we can help, and feel free to contact me at shenkind@rebny.com or my telephone 212-616-5299. Thank you all.
All right, thank you. Did you have, I guess, anything specific that you wanted to add at this opportunity on the 4 topics that I had just described? Ms. Henkind?
Oh, no, thank you.
Okay. Thank you. So the next speaker that had pre-registered is Anthony Gatto. If we could please unmute Mr. Gatto's microphone. Mr. Gatto, are you there?
Yes, Dave, thank you. And good afternoon, everyone. My name is Anthony Gatto. I'm General Counsel with the New York State Association of Realtors. Like REBNY, NYSAR represents state licensees throughout New York State, and would like to provide comment regarding the 6 hours of fair housing training for the Salesperson Qualification course. NYSAR had a meeting of a number of instructors that were members, and to discuss what should be contained within the 6 hours. During the meeting, we took into consideration the new requirements for CE, including cultural competency and implicit bias training, and that should also be included within those 6 hours, although realize that that 6 hours is limited as far as how much content we can actually fit into those 6 hours. We didn't feel that a licensee should not have that training in the first 6 hours during the qualification course and only be exposed to it during their continuing education cycle. The salesperson qualification course will be the foundation of the education that these individuals will receive before they go out practicing and interacting with consumers. So understanding the full range of fair housing and discrimination in the sale or rental of real property is important at this first step of their hopefully successful career. So taking into consideration the 4 items that were contained within the statute, NYSAR has assigned hourly requirements for each, and just as a suggestion. So the legacy of segregation and unequal treatment and lack of access to opportunity in housing, approximately 1 hour of that 6 should be dedicated to that. Number 2 and 3, regarding unequal access to amenities and resources on the basis of race, disability, and other protected characteristics, as well as federal, state, and local fair housing laws. We felt that those 2 would work together. They really wouldn't be separate sections, so to speak. So dedicating half of those 6 hours in 3 hours to those matters. It's extremely important for licensees to understand the fair housing laws. Again, this is their first instance as far as being exposed to the real estate industry is concerned. The anti-bias training, number 4, we interpreted that to mean implicit bias. So we should have the licensees, again, be educated in the same manner they would be when they go to take their continuing education courses. So that 1 hour would be related to implicit bias. And for last, again, for cultural competency, another hour for cultural competency. We're not necessarily saying that these would be blocked up 1 hour for the first section, 3 hours for the second. A lot of them are intertwined because there is some overlap in there, but these are just suggested times for those required subjects, David. So thank you.
Thank you very much. Are there any other members of the public that would like to say something with respect to the educational provisions? If there is anyone, please. Oh, so we have. I'm sorry?
I would like to say something.
Oh, okay. Board member Tricia O'Connor would like to say something.
I'm an instructor, and I've taken many fair housing courses. I know there's a standard, but every time I've taken a fair housing, it's always been different. Every single time I've taken fair housing continuing education, every instructor teaches it different. And I think we need to come up with a way to have a little more standard, because you can have a curriculum, you can have a syllabus, and everyone is giving it different. They're omitting some stuff, they're putting their own stuff. And like I said, I've been an instructor for many, many years, over a decade, and I've sat in many continuing education, and it's taught differently every single time. So that's something that we really need to look at and have more of a standard, at least for this particular type of course, to make sure whether we're from Albany all the way downstate that everyone is teaching it the same way and being taught the same way. Curriculum is not enough because you can still go off however you choose to teach it.
Thank you. I think we could certainly.
Dave. Oh,
hello?
I'm sorry. Dave, it's Jody. I just wanted to mention to you that I do have someone that reached out to me who is not on WebEx, so they dialed in, so cannot raise their hand. So when you're ready for that person, I'll let you know who it is, or unless you want me to let you know now.
I don't believe there's anyone else that has pre-registered or has advised that they wish to speak. So certainly if you can identify them, we can unmute them, have that person speak.
Okay, the name is Ed Beninati.
I'm sorry, you said Ed
Bedinati.
Donati?
Bedinati.
I'm not seeing an Ed Bedinati. Did they call under a phone number?
Yeah.
Okay. Would you know the last 2 digits by any chance?
I will ask the person that contacted me. $5544. Or sorry, 5545.
Okay, and they are unmuted.
Jody,
Hello?
could you repeat the spelling of the last name?
Is Bedinotti.
E as in boy?
Yes.
Yes.
ED.
And Nadi, okay,
Yes.
great, thank you.
Hello?
Yeah, that phone number is unmuted.
Okay, can you hear me?
Yes.
Yes, we can hear you.
Okay, hi. Good afternoon. My name is Ed Bedinati. I am a real estate appraiser, and I am the chair of the NYS Appraisal Committee. And I would like just to comment on the new ANSI standard that went into effect April 1st.
So
I'm sorry?
can we were opening up for conversations now on the educational requirement. If you'd like to speak about the ANSI requirement, just so that we have some order here, can we call on you when we get to the open discussion? We thought you wanted to discuss the educational components under the new statute.
No, that's okay.
Okay, so we'll call on you after all the other public speakers are called on for the educational component. So sorry about that. The next person that wished to speak was Lynn Fields. Can we please unmute Lynn Fields?
She's unmuted.
Okay.
The opportunity to address you today. My name is Lynn Fields, or Linda Fields. I have been a licensed real estate broker since 1979. I have been an instructor since 1983, and I am also an instructor for the New York State Association of Realtors. I would like to speak in support of the changes that are happening with this. I tend to pride myself on teaching fair housing courses, and I find it very difficult to get the information in just simply 3 hours. I think what is going on out in the real world is outrageous, and I think this will certainly help new people coming into the business. They need to know more about fair housing, anti-bias, implicit bias, cultural competency, and this edition will do very well for them. It's a stepping stone that I think is fantastic. So I just wanted to speak in support.
Thank you for your comment. Do you have anything in terms of a specific comment or recommendation that the department should consider when developing the regulations to enact the statute?
Not at this point. I find quite honestly that if it would have been more than 6 hours, I would have been very happy because they need the education. To speak to the one of the members who said that the classes need to have some sort of continuity, I agree with that because, as you've said, there are so many classes and so many different ways of teaching. I think this will be a big help.
Thank you for your comment.
Thank you for your time.
So I'm going to just ask if any of the public participants are there, just give you an opportunity that if there is anyone that would like to speak publicly regarding the educational requirements, please raise your hand. Please note that the what will happen next, as Director DeLallo mentioned, is that the department will work on the coursework. We are required to develop regulations pursuant to the new statute. So when the regulations are published, there'll be another opportunity for members of the public to submit comments to the department that will be considered as part of the rulemaking process under the State Administrative Procedure Act. So I'm being advised that there are no other public comments with respect to the education. I thank everyone who pre-registered, who spoke, volunteered their time. And now, if we could please go back to Mr. Donati, who wanted to provide public comment on the ANSI requirements. So can we please unmute Mr. Donati?
He is unmuted.
Thank you.
Again, my name is Ed Bedinati. I'm a real estate appraiser, and I am the current chair of the NYS Appraisal Committee. And I would just like to speak publicly in regards to the answering measuring standard, which just went into effect April 1st for all loans to be delivered to Fannie Mae. Most people, most agents and brokers are not even aware that there is such a thing as called the answering measuring standard. And a lot of appraisers, to be honest with you, especially in New York State, are not aware of it either. What the answering measuring standards is a way of calculating a square footage for a single family residential property. It differs vastly from the way square footage is typically measured and calculated within New York State. There is no uniform measuring standard nationwide. There never has been. They've always tried to implement one, but the problem is each individual state, as far as appraisal goes, has their own department which enforces and regulates use path. So basically, there can be different rules in different states. In New York State, the agents and brokers, as far as I know, there's no law that requires them to measure a house or a property when they list it for sale. Typically, they go by the recorded or reported assessor records. Or if there's a difficult house, we'll get a call, an appraiser, to go out and measure a property for them. And as an appraiser, we will typically measure a house, knowing the market area that we're in ways that we know other houses have been measured in the past, typically gained from experience over time. And we will be comparing the houses to apples and making adjustments accordingly. With this ANSI standard, it's a client-imposed measuring standard that the general public is not aware of. And as an appraiser, we are supposed to follow. We interpret the market. We don't dictate or make the market. In this case, we are being told that we have to actually dictate the market, dictate the way the square footage of a house is calculated and reported, which goes against the definition of market value. For real estate licensees and brokers, this creates a very big problem, because if they have a cape with ceiling heights that don't meet this ANSI requirement, they could be marketing a house, as they always did, at say a 1,500 square foot house. But the appraiser for loans to be delivered to Fannie Mae is going to be measuring and delivering a 1,000 square foot house. And you can imagine where the confusion is going to be in trying to explain to a seller or buyer that your house is technically only 1,000 square feet. They've come up with vast ways that the appraiser can account for the difference and try to make up for it. But again, by doing that and trying to do that, the appraiser is put in a situation where they can be violating use path because they are not following what's common and typical in the market. And I would just like to point out a couple things really quick and not take too much time. But there is a frequently asked question within use path that says, do appraisers have to follow ANSI? The general answer was no, but it said it could be an additional assignment condition. What the ASB did not add after that was the definition of value used can determine whether or not the measuring to the ANSI standard is an acceptable assignment condition. And they have an advisory opinion number 22, which is almost 6 pages long, deals specifically with the scope of work an appraiser follows for a market value appraisal for real property. And it clearly states within that advisory opinion that market value appraisals are distinct from appraisals using other types of value, because market value appraisals are based on the market perspective and on a normal or typical premise. So what happens is the relevant characteristics of a property, understanding how buyers and sellers are most likely to respond to a subject property under the conditions stated and a specific value definition. In a market value assignment, the relevant characteristics are those that have a significant impact on the property's marketability, and that the market perspective replaces the buyer, seller, lender, agent's perspective that might apply in other appraisals. So basically, the market perspective would directly affect our scope of work, and the public's expectation that a market value appraisal reflects only the perspectives of the marketplace and is not affected by such other criteria as an intended user's objectives. USPAP clearly states out that the market dictates it and takes the precedence of any lender requirement. And Fannie Mae is now dictating a lender requirement that goes against the market perspective in the state of New York. So again, in the state of New York, the Department of State is the department that is tasked with interpreting and enforcing USPAP. I feel that the Department of State should revisit USPAP, especially advisory opinion number 22, which I just read many excerpts from. And Standard Rule 1-2 of USPAP also dictates that the appraiser determines the relative characteristics of the property. That's very important. The appraiser makes that determination based on the market that they live in, not the client. This is only for Fannie Mae, which 62% of loans are delivered to Fannie Mae, but a lot of AMCs, the management companies, are requiring appraisers to measure this way across the board. They won't know if it's going conventional or to Freddie Mac. But you can see, as far as fair housing goes, are you going to have a disparate impact? Are you going to have smaller type houses in a certain value range in a certain area? The appraiser does not take into the ethical makeup of the residents at all when we're doing the value. We just certainly look at numbers. But one could say, well, what are the typical occupants in that value range? And does it create a disparate impact? So there's a lot of implications that could arise. And from a real estate licensee's perspective, they're listing a house. Are they listing it as 1,500 square feet, 3 bedrooms, 2 baths? Are they listing it as 1,000 square feet? It can create all types of problems. So I just wanted to put it out there of things that are occurring right now. Most people are not aware of it. And I think the Department of State really needs to look back at what was already advised within Advisory Opinion 22 in USPAP to see that, no, this is clearly not following the market value. So if the appraiser in New York State were to follow these guidelines, they would have to alter their definition of value, because it would not equal the definition of market value, which one of the key components is that both buyer and seller are well aware. Well, buyer and seller are not well aware in New York State because properties are not listed, bought, and sold based on an ANSI measurement square footage. So I just wanted to make everybody aware of that. It is a great concern that's going on right now. And I think that it's something that needs to be addressed and looked into. And I just wanted to put that on record in the public comment so that it is a grave concern and something that if we can look into it, that would be great.
Okay.
Thank you.
Thank you for your comment. I've been advised by staff that a public member, Jennifer, and I apologize, Vucetic, would like to provide public comment on the educational course requirement. So can we please unmute her?
I actually, you pronounced my name correctly. I am Jennifer Vucetic, and I am the current president of the New York State Association of Realtors. I would like to comment about the Fannie Mae requirement for the if that's okay.
Okay, so just to be clear, it's not about the educational requirements?
Correct.
Okay, sure, absolutely.
Not an appraiser, and Ed did a very eloquent job of explaining the troubles from his point of view. In an effort to educate our membership that this was passed effective April 1st, we've been met with numerous questions. There seems to be a lot of confusion, and a lot of realtors don't even know that this was put into effect. It will directly affect affordable housing. Many of the homes that are going to be affected by this new standard of measurement are over 100 years old, may have been sold 10 times and always were, recorded as having 1,800 square feet. Now the second floor may have a knee-high wall of 2 feet, and the center of the room is 6.5 feet, and only that square footage can be recorded. So now you may have a home that's now in fact only 1,000 square feet. This is usually the lower end of the market and will directly affect affordable housing. So we just wanted to go on the record and let you know that, and we really must work proactively to address this and not reactively. Thank you very much.
Thank you for your comment. So I'm not being informed that there's any other members of the public that wish to provide public comment on the educational components or any other public comments with respect to any observations about real estate practice in New York, but I'll just double check to make sure that there's no one else who wishes to speak. Okay, with no volunteers, thank everyone for your time. And the public hearing pursuant to RPL 442I paragraph 6, as well as the public hearing with respect to the requirements to hold a public hearing pursuant to Chapter 697 of the laws of 2001 are now closed. Thank you, everybody, for your time.
Thank you.
That's quiet. I didn't hear you come in. Then I saw you on the screen back there.